Let's do something we like to call social media check-in. What do we got, guys?
All right, our first one comes from Balul Anwar on Facebook asking if I pleaded guilty to public intoxication in 2016 in Virginia, and that is the only crime on my record. How will it affect my case when I file for citizenship?
I doubt it, because public intoxication is probably not bad moral character per se. I mean, if you're walking around drunk every day and it's every month your public intoxication, that's a different story. But I think one time, I think you're okay.
Ann Martin on Facebook, can a green card holder marry someone and then file for an adjustment of status? How long does this usually take?
If they are, the answer is yes, if their person is in legal status and priority dates remain to be current, yes.
Okay, PD, this is an email. It's pretty long, so
oh gosh,
just bear with me.
All right.
I'm a U.S. citizen and have been with my non-citizen companion for 15 years and lived out of the U.S. the majority of the time. After being denied for a tourist visa 3 times, we used someone who said they could help us by claiming a different common law wife. But he was denied a tourist visa for the 4th time in 2018. Now, we got married June 2019 and submitted the I-130 petition with a priority date of October 15, 2019. I returned to the U.S. and began work in November 2019 to establish domicile. Now, okay, this is the last part. After 11 months, I received a notice from USCIS that he is denied a spousal visa because we did not prove a dissolution to the common law relationship that was invented. Now, what can we do to resolve this nightmare?
Refile again. Get evidence. Well, first of all, common law marriage is not a civil marriage. Immigration should know that. Go to the area wherever you claim to have gotten married from that particular country. Every country has somewhere where you can get proof of marriages, and you're going to go to that particular civil government agency where whatever country you're in, and get a letter saying that they have done a search of marriages throughout the entire country or that province, or you have to go to all the individual provinces in the country where you live, and they've done this search and there is no record of any marriage between your husband and whoever this made-up lady is. There's your proof. He was never married to anybody. Now, after you file the I-130, he's going to go to the U.S. Embassy and they're going to say, wait a second, you were here a few years ago, pal, and you said you were married to this lady, and now we have some evidence here that says you were never married to her. So you lied to us back then. You're denied. But then you got to file a waiver. So you got to get to the point where you can file a waiver, and that's how it's going to be.
Wow.
Jennifer James on Facebook. If I am living in Jamaica and my son's sister who lives in the United States wants to adopt my son, who is a 14-year-old Jamaican citizen, how exactly would it work?
Well, the son has to be an orphan. So if you're not adopting an orphan, you got to prove you lived in the same household with that child before 16. It's going to be difficult unless you're actually living in Jamaica with him. So first, orphan. And if he's going to adopt your son, you're not going to go commit suicide to orphan your kid. So basically, your parental rights have to be stripped. You can't consent to it. It has to be stripped because you're not able to take care of the child because of, your economic condition, or you have abandoned the child. But somehow your parental rights have to be stripped from you by a government agency. And that child has to be an orphan. And then you can start an orphan petition. But it's a whole process. And this woman is asking about an adoption of her child. So who knows? They need a consultation. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.